Please join me in welcoming Dean Andy Perlman. Thank you very much for having me. It is a real treat and a pleasure to join you. You're doing some very exciting work under the leadership of your dean. And I'm pleased to tell you a little bit about what we've been doing at Suffolk, but really taking a step back and thinking about where are we going as a legal industry. Many of you are law students, so almost all of you here are law students. And I think you should be especially interested in the future of legal services. What is the delivery of legal services going to look like during the course of your careers? To answer that question, I always like to take a step backwards and to look to the past and remember the ways in which legal services were delivered in the past. And I think a picture can sometimes speak 1,000 words. This picture is a nice one. This was what legal services looked like in the past. Couple of guys, typically guys, sitting around a table with some papers back and forth, maybe with some books on the shelves. And there are some words that come to mind when we think about the way that legal services were delivered in the past. Lawyers were typically practicing alone. Solo practice was by far the most common way that lawyers practiced. There were a lot of trials. Lawyers were generalists. They handled pretty much anything that came through the door. And they handled it from soup to nuts. There really wasn't an associate you could delegate to or a paralegal. Lawyers pretty much handled it all. When we think about legal services today and the practice of law today, there's an entirely new vocabulary that comes to mind. There's new knowledge, there are new skills, there's a new way of doing things that I think can best be characterized by two words, and those words are rapid change. So, the question that I often ask is, what is the typical lawyer reaction to all of the changes and disruptions taking place throughout our economy and the world? Now, I'm a law professor by training, as you just heard from your dean, and so I like to pose multiple choice questions. This one has two possible answers. So, is the answer to this question this guy right here? And bonus points for anybody who can properly identify this gentleman. Captain Jean-Luc Picard, okay, so a winner over here is when he was captured by the Borg, but he became one with technology, right? So is this what we imagine lawyers to be doing? That is, they integrate technology into their soul and they become one with technology for all intents and purposes? Or is the answer this? That we stick our heads in the sand and we ignore all of these technological developments that are taking place around the world. Now, oftentimes, people recognize that as the more common answer when they look at the legal profession. And what I like to ask is why? Why is it that lawyers in particular are relatively slow to adapt to changes in technology? And here is where I think we, and the general we here is law schools and legal education, are at least partly to blame for the legal profession's relative slow pace in adopting technology and innovation. So let me take you back in time again and ask the question, what did the delivery of legal services look like a century or so ago, at the time of that opening slide of those two gentlemen sitting around the table? So this person here came up with a new approach to law school. His name was Christopher Columbus Langdell, and prior to Langdellian innovation, the way that lawyers prepared for their work was they either apprenticed with other lawyers or they read descriptions of the law, treatises, descriptions of the law, but not necessarily the law itself. That was the approach. Langdell came up with a different approach. What he said is, let's have law students read primary materials, primarily appellate opinions, teach them how to extract from those appellate opinions basic legal principles, and then apply those principles to a set of facts that the students had never seen before. The so-called case method of legal instruction, which spread throughout just about every law school in the country. That was more than 100 years ago, and a lot has changed since Langdell's day, for all the reasons that I just identified. And so the question is, what does legal education look like today? Well, pretty much the same guy, right? Because the description that I just gave to you should sound very familiar. It's the way that we still teach the law today. Now, I want to be fair to law schools. After all, I am the dean of one, and I am inside of one here giving a lecture. So I want to be fair. And we have pushed Langdell off to the side just a little bit. And we have added new doctrinal knowledge, new areas of law that have emerged. And we have certainly incorporated new skills. Legal writing courses, clinical legal education have been absolutely essential to the development and evolution of legal education. But at the end of the day, my claim to you, perhaps a provocative claim, is that we are still inherently backwards looking as a profession and in our orientation in legal education. We tend to look to the past, to precedents, to the way things have always been done, rather than to the future and trying to anticipate where the delivery of legal services is going so that we can best serve our clients, whether they are the person on Main Street or the most sophisticated clients on Wall Street, and everyone in between. We need to serve them well. Now, here is a great quote for those of you who are hockey fans. Wayne Gretzky was fond of saying, "Skate to where the puck is going, not where it is right now." Legal futurist, a guy named Richard Susskind, quoted him. And so this is me quoting Richard Susskind, quoting Wayne Gretzky for this proposition. And I think it's a great one. And it's not just a good one for hockey players. It seems to me it's a particularly good one for future lawyers. Where is the puck going in terms of your career? Don't look at where it is only right now. So where is the puck going? Here's from Richard Susskind's book. It's almost already becoming a little dated, from 2010. And he used this image, and I think it nicely captures what is going on in the legal marketplace right now. And let me start with the bespoke end of this diagram and work my way across to help explain it. So how many of you are familiar with the word bespoke? A few of you. It's a British word that means tailored, and it's oftentimes used in the context of clothing. So if you're getting bespoke clothing, a bespoke suit, for example, you'll have a tailor who takes your measurements and creates clothing precisely to your measurements. And in case you're wondering, this is not a bespoke suit. I just bought it off the rack. So bespoke is the tailored, highly customized approach. Well, guess what? Legal services can be exactly the same way. Highly bespoke, highly tailored, highly customized for the needs of every individual client. Every new matter that comes through the door, you're creating a solution that is perfectly tailored to that particular client's needs. And that's the way we teach in law school, is to think along bespoke legal services lines. Very valuable, very important, but it's not the only way that legal services are being delivered anymore. So let me take you across the next part of this spectrum. What happens over time, you can choose almost any area of law, certain aspects of it become standardized. Maybe you're working in litigation. Certain language in interrogatories or document requests or complaints and answers are standardized. You don't have to bespoke, custom tailor the language anymore. It's already there and you can reuse it. At some point, through systematization and technology, you can generate that information in automated ways to make it even more efficient to deliver that information and service. Eventually, you can turn the entire service around, make it available to the public to purchase, so that the lawyer does not necessarily even have to be involved in a vast majority of the process. And at some point, the legal service becomes so easy to produce, it is for all intents and purposes a commodity, and there is very little money to be made from it anymore. Let me give you an example of one area of law that I think has gone through this transition. Let's choose basic wills. If you go back to 1980 or so, and you think about the way that a will was crafted back then, it was still largely that opening slide. A couple of people sitting around a table. Client comes in, comes to a lawyer, says, I want a will. The lawyer will ask a series of questions. Maybe some of those questions are standardized, but bespoke, custom-tailored creation. And think about how the document was created back then. Typewriter, right? And each new document was created from scratch. Again, maybe some standardized features, but largely a bespoke operation. Now let's fast forward from 1980 until today. And what you see is that basic wills, if they are not yet a commodity, they are getting awfully close. If you want a very simple will, you can get that done without going to a lawyer at almost no cost. So if somebody were to come to me today and say, I want to spend my career creating basic wills for people, I would not advise that. I don't think that there's a lot of future in that area of law. But it's not just wills. If you think about transactional work and document work across the legal industry, I'm not suggesting that everything is going to commoditization, but what we're seeing is a splintering of the marketplace. We're seeing parts of transactional work being delivered at different points along the spectrum. So let me give you another example of commoditized work. If you're going to incorporate a small business, you don't need to go to a lawyer anymore. You can get that done on a government website. You can go to a company like LegalZoom. LegalZoom now incorporates more businesses than any law firm in the nation, right? They're not a law firm. They are an automated legal document assembly company. And so going to them, packaged. They are a perfect example of a packaged legal services provider. They've created technology, automated various kinds of services, turned it around, made it available to the public for a fee. Systematized legal service. So if you're a lawyer and you do home closings, if any of you have purchased a home or refinanced a home, then you'll have gone through this experience. A lawyer will show up with a very large stack of documents for you to sign. That lawyer did not create those documents by opening up a new document, saving it as a new document, and doing a find and replace. There is an automated way to create all of that documentation. So systematization of that legal service is driving down the cost of home mortgage closings and the like. But here's the point. In law school, when you're learning contracts or you're learning any kind of transactional work, it's still bespoke. You're still learning only an increasingly small portion of the legal services industry when we focus only on bespoke work. Now, don't mistake me. I don't want to suggest we shouldn't be teaching that. We absolutely should. But I believe that if you want to prepare yourselves in the best way possible for where the legal industry is going, it's important to understand ways that you can drive down cost, become more efficient, because it is affecting every part of the legal industry, from the most sophisticated consumers of legal services down to the person who just needs a simple will. And it's not just transactional work. For those of you who are interested in litigation, we're seeing this here as well. A splintering of the market where different parts of dispute resolution are being delivered in different ways. Let me give you a great example of commoditization. So there's a company called Modria. How many of you have heard of Modria? Now, this is pretty typical when I'm talking with law students and lawyers. Very few hands go up. So it usually surprises people when I tell them that Modria now resolves more disputes in the United States than the entire US court system combined. And nobody's heard of them. Or at least audiences like this have never heard of them. So who are they? You may have actually used them without knowing about it. They are the automated dispute resolution platform, or at least they got started as the automated dispute resolution platform for eBay and PayPal. Let me give you an example of how it works, because I had personal experience with it. So a number of years ago, I bought a television at Best Buy, and they gave me a gift card. I didn't need the gift card, so I decided to sell it on eBay. Somebody purchased it, and after I received payment and got the address, I put the gift card in an envelope, sealed it up, put it in the mail, and away it went. A week later, the person who bought the gift card tells me that he didn't get it. and he wanted his money back. I said, well, I sent it to you. I don't know what the problem is. And so we had a dispute. I didn't want to give the money back because I sent it, and he claims never to have received it. So what do you do? It was a $100 gift card. We're not going to go to court over it. That wouldn't be a good use of anybody's time. So eBay has an automated online dispute resolution tool that automates the resolution of that process. And so we went through a series of automated questions and answers, and at the end of the day I was asked the question, did I have a return receipt? Did I have any evidence that I had sent it in the mail? The answer to that question was no, I didn't. I just put it in an envelope, sealed it, and put it in the mailbox. And according to eBay's terms, that meant that I lost. Now, I can tell you that as a former litigator, this was infuriating, but it was also fair. I recognize that if there was a burden that would fall on somebody, it should be on the person who could have taken the measure of simply getting a return receipt. I didn't do that, and so I lost. Now, what's interesting about this, you might think, okay, well that's nice for solving disputes on eBay and PayPal. Modria got spun off as a separate company and was recently purchased by a much larger company called Tyler Technologies. Now, Tyler Technologies works in a couple of dozen states around the country and does technology for courts. And what we're seeing now are a number of courts, not only in the United States, but around the world, deploying online dispute resolution to help people resolve their disputes outside of courts and in an online platform using exactly the kind of method that I was just describing that's been used in eBay and PayPal. The future of dispute resolution and litigation is going to increasingly involve automated ways of resolving disputes. Now, this can create some opportunities and also some threats, and there are potential challenges that we could talk about, but it's a very important development, I think, in the future of dispute resolution. There are package solutions, so sometimes if you go into a courthouse, you can find a kiosk that gives you information. This is an example of a packaged legal service in the dispute resolution context. You can automate the creation of lots of different discovery documents and other kinds of documents in litigation. Now, I taught civil procedure. I have taught civil procedure for many years. In fact, wrote a case book in civil procedure. So I know that we still think in bespoke terms. And it's valuable to understand how to litigate cases in bespoke terms, and I don't want to suggest otherwise. But we are taking a risk by ignoring all of these other ways that dispute resolution services are taking place. By understanding them, I think we put ourselves in a best position to succeed as the years move on. So, bottom line, to compete and serve the public, I believe that all of us in legal education have to think outside the bespoke box. We need to be introducing all of you to new ways of delivering your services. Clients are increasingly demanding it. So, how can law schools respond? There's an ABA task force on the future of legal education in 2014. It issued a report and said that there is a mismatch between the curricula at most law schools and their goals. And the report suggested that there need to be that because there are changes in delivery of legal services, we need to rethink what we teach. But only a modest number of law schools at that time were doing anything about it. Modest, but there were some, and that list is growing. And you'll see the first one on there, not just because I'm visiting here, but it came first alphabetically, is BYU. You're doing great work in your Law X design lab, doing really groundbreaking work that draws on exactly the principles that I was just describing to deliver legal services in entirely different ways. And the people who are involved in that are going to come out of it with a new way of thinking about the delivery of legal services that I believe will put them in the best position to succeed in the years ahead. I will talk just very briefly about my own school, just to give you a sense of the kind of courses that you could create. So what we did is create a concentration. It's kind of a law school major in legal innovation and technology where we're teaching things like legal project management and process improvement, which are concepts from the business world that have been around for decades and are working their way into law. It's just another way of figuring out what are the most efficient ways of getting from X to Y. And the way law has gone about it is not that way. We have a single lawyer in like that first slide who comes in and tries to do it all and doesn't think about the most efficient way to do things, primarily because lawyers traditionally have not had an incentive to be as efficient as possible. Why? Because we bill by the hour. Why would we want to do something in a half an hour when we could spend an hour on it? Right? That doesn't make good financial sense. And so we have not, to this point in time, had much of an incentive to develop new efficiencies. These concepts of project management, process improvement, are going to be increasingly important as clients are no longer accepting the billable hour as the way in which they want their lawyers to do their work. And there's automation. We have classes on automated legal document assembly and expert system tools and legal process and legal design thinking. So there are all sorts of new ways of thinking about our work that I think are going to be more and more valuable in the years ahead. And employers are looking for these skills. Law firms are hiring legal project managers or knowledge management experts. They're looking for people to do automated document assembly. There are companies out there, startups, that are looking for lawyers to work in automated document assembly. There's obviously e-discovery. There are companies that do legal process outsourcing for the most sophisticated legal departments in the world. There's an organization called CLOC, the Corporate Legal Operations Consortium, made up of some of the most influential legal department professionals in the world who oversee the operations of legal departments and control literally billions of dollars in legal spend. They are looking for people with these skills. And because they control legal spend, when they go to their outside counsel and they're asking them questions before they hire them, they want to know, do you have legal project managers on your team? Have the lawyers who are on your team gone through any kind of training to improve their efficiency? And guess what? We're not going to let you bill by the hour anymore. We're going to charge you, we want a fixed rate. And what does the law firm do when they suddenly are only going to get paid a fixed amount for a particular amount of work? Well, they're going to want to find lawyers who know how to deliver those services as efficiently as possible. And it's happening. I'll just give you one example. Microsoft announced last year that within 2 years, 90% of their legal work is going to be fixed fee, not by the hour anymore. That's a dramatic shift, and I think we're going to see more and more companies. So we're talking about the upper end, right? Those at the big, for those of you who are going off to the largest law firms in the world, these are the pressures you're going to be seeing. These are the pressures that your law firms are going to be facing. They're going to see more and more of their work moving away from the billable hour, away from those incentives to spend as much time as you want on a legal matter, and the incentives are going to flip. And suddenly these law firms are going to say, we want lawyers who are not only great in the traditional sense, that's always going to be true, but also know how to think about delivering those services in new ways. So, a legal solution architect. This is a job that didn't even exist 5 years ago, and it's a wonderful success story. In the very first year we graduated somebody in our concentration, I got a call from a law firm in the Northwest, Davis Wright Tremaine. They had a new arm of the firm called De Novo. They were looking to hire a legal solutions architect, somebody who had a legal background but could think in innovative ways and work with the lawyers on their team and their clients to come up with a new approach. Come up with a new approach that drives down the cost of legal services, because the clients were complaining that legal services are costing too much. And so law firms are creating entirely new categories of legal professionals to do this kind of work. So let me anticipate some objections and then turn it over to you to ask questions and tell me why I'm wrong. And if I'm not wrong, what classes you're going to want to start taking. So feel free to push back on any of it. So here are some objections that I could anticipate. Number one, this all sounds great. Learn it after law school. That's not what law school is about. Law school is about learning the law. It's learning a way of thinking, of concepts, right? The stuff that I'm describing, you can learn it after law school, much the same way you could learn certain kinds of document drafting or depositions after law school. Well, the problem with that is that unlike a lot of skills that you could pick up after you graduate, the skills that I'm talking about, those are not them. And the problem is, lawyers don't have them. Experienced lawyers have never learned about legal project management or process improvement or legal design thinking. That's not something they know. They're not going to be able to teach you. Unless you learn it in law school, it's going to be very hard to pick it up in practice. Another reason is it's going to make you more valuable for exactly the reason that I just said, because lawyers don't have these skills. Lawyers haven't learned them. If you graduate with them and the profession increasingly recognizes how important they are, it's just going to make you more valuable. So that's why I think law students should be learning these skills. You're not going to learn it in practice, and if you learn it in law school, you're going to be all the more valuable in the market. Another objection. Learning technology is a waste of time because it's just going to change tomorrow. You learn it today, great, but we all know how quickly software changes. So what's a response? The objective should be, in my view, teaching a new kind of issue spotting. In other words, why do you learn various areas of law in law school? It's not because you need to know what the doctrine of personal jurisdiction was under Pennoyer versus Neff in the 19th century. That's not the reason you read those older cases. Doctrines change, right? If we wanted to take this objection seriously, we wouldn't read so much case law from the 19th century or the early 20th century. The law is different today. We don't read those early cases and changes in or areas of law that have changed just because we're learning new concepts, a new way of, you're retraining your mind to think conceptually about the law. I view legal innovation and technology the same way. You might learn specific areas of technology that might differ tomorrow, to be sure. What you should be learning is a kind of issue spotting in terms of legal services delivery, so that when you get out in practice, whether you're going into a huge firm or a small firm or an in-house legal department or someplace else, you say, you know, we're delivering this service this way, we're representing a client in this way. Based on what I learned in law school, there's a better approach. The software that I was exposed to might have changed. The particulars might be different. But I do think that there is a more efficient way that we can go about it. And if you're able to point that out, that is going to make you much more valuable than the typical lawyer who doesn't think along those lines and can't think along those lines. Lawyers don't really need these skills. Maybe these are jobs that are at the lower end, you know, the kind of jobs that large law firms won't ever really need. I can just tell you that the market is saying otherwise. Like I said, companies like Microsoft are now going to expect 90% of the legal work that they do to not be billed by the hour. And the law firms are responding, and they're recognizing that they can't do things the way they always have. And law firms are creating R&D arms. They're looking for people who can think about what they do in entirely new ways. So this isn't about any particular point along the legal market spectrum. This is happening throughout the legal economy. So you do, I believe, need to understand these skills no matter what area of law you pursue. So doesn't this take away from what you all need to be learning in law school, the foundational concepts, the basic law? I would say, of course, we want you to learn those skills. We want you to learn traditional knowledge. This is intended to supplement it. I'm not saying do away with civil procedure or contracts or property or torts. I'm saying get through the first year, take a handful of other additional important foundational concept courses in your upper level, but then supplement that learning with the kind of instruction that I'm talking about. And I also think that traditional skills like analytical skills can be taught using legal innovation and technology. If you automate, I'll use a very simple example. If you're going to automate the creation of a basic will, what do you have to do in order to achieve that result? Just imagine how deep your substantive knowledge has to be to create a guided questionnaire that would produce a good basic will. So if you're teaching automated document assembly in a class and you're using a substantive area of law, you would have to know that law really well. You'd have to be very good at legal analysis to make it work. So I believe that teaching these skills of automation as a way of example are actually quite consistent with teaching the skills that have long been valuable to lawyers and that are taught in law schools. So what's the alternative? Why do I think this is so important? Let's look at how technology is transforming so many other industries in our economy. Let me start with this company. I think you might still recognize them. Do you remember them? You know what happened to them because of technology? Well, how about shopping? We still have grocery stores, but we certainly don't shop the same way that we used to shop. How about the way we take pictures? We certainly do it in different ways now. But how about more personal services, right, that people provide, not just a camera? Well, you can ask taxi cab drivers what's happened to them as a result of technology. But you might say, well, what about more professional services? Well, in banking, we're certainly seeing an automation of their services. But you might say, that's not professional services. That's not going to affect people like lawyers. Well, ask accountants who used to do a lot of this work by hand, what's happened to them and what's happened to a lot of their customers who now do their taxes online. And when you see industry after industry, including professional services, being automated and disrupted as a result of technology, we wonder and go back to the first slide and think, what is the next slide going to look like for us? That is the question that I'm trying to answer, and somewhat provocatively. I want to hear what your answers are, and I want to hear what questions you have for me. So feel free to use the microphones and let me know your thoughts.
In law school, where there's such an emphasis on issues of plagiarism, how do you incorporate these ideas of automated reuse of pre-existing materials in a way that doesn't interfere with the teaching of the ethics of doing your own work?
Interesting. So I don't view automation as a form of plagiarism any more than automating tax returns is somehow problematic. What you're doing is replicating knowledge. If you look at any kind of basic will done the old-fashioned way, what you see are the same phrases and the same clauses being used over and over again. Even back in the day when people were typing up a will, it's not like they were trying to come up with a new way of phrasing a certain section. They would use very well-established phrasing and use it over and over again. That's not plagiarism. That's actually good lawyering. Now, it's got to be your own phrasing, right? And there's nothing wrong with that. You can have plagiarism in the old-fashioned way if you're taking somebody else's work and using it as your own. But I don't view automation, particularly your own automation, as in any way ethically problematic. But feel free to follow up with me if you're not convinced by that response. Yes?
I have a few questions. My first is, what about in-house counsel? Isn't that kind of already the point of a flat fee attorney? And how do you see in-house counsel interacting with this new system? And then I have two more questions. I'll let you answer first.
Okay. So in terms of in-house counsel, they're the ones who are asking their outside counsel to change, right? So in-house, and I'm not sure if this was exactly what your question was, but in-house counsel are paid a salary and they're not billing by the hour, right? But the in-house counsel are under pressure by the client, the corporation, to reduce their legal costs. So when they're going to outside law firms, the in-house counsel are now demanding those outside law firms to do things differently. So that's where the Microsoft example came in, is that Microsoft is now, their in-house team has said, we want 90% of our legal work not to be by the hour anymore. And so those are the marching orders to everybody in the in-house legal team, is that when you're working with outside counsel, make sure that they are, you're complying with this directive. I don't know, does that answer your question?
That's interesting. I didn't realize that was coming from the in-house counsel. And the other two questions I have are, what about the availability of the internet? Because we like to tout that Netflix replaced Blockbuster, but in reality, Redbox replaced Blockbuster for a lot of households that don't have access to the internet regularly.
Yeah.
And who don't have the technology. So what about the lower echelon that isn't as able to access these tools? And then, in addition to that, my last question is, what about the quality of the work? Because the idea is that more time creates better quality. And so just how would you address those two possibilities for pitfalls?
Great. So let's talk about access to the internet for starters. Now, in those locations, oftentimes there are already a problem with access to legal services because there are no lawyers, period, right? Let alone access to legal services. At the very least, they might be able to go to a library that has a terminal that they could access these legal services, and it's going to be a heck of a lot cheaper than paying for a lawyer. So in communities where people don't have access to the internet, frequently there are poorer communities who wouldn't be able to afford a lawyer anyway. So that goes to the second question about quality. Nobody, I would actually argue two things. Number one, the quality actually could be superior to going to a lawyer. Let me use a will as a basic example. If you create a very good automated process, you personally create the questions and answers. You're going there, not stealing from anybody, right? You're using your own knowledge about trust and estates to create the Q&A that gets you to a will, right? And it's like a checklist. If anybody familiar with the checklist manifesto, where if you go through a checklist, you're much less likely to make a mistake. Pilots go through a checklist to avoid making a mistake. If you can automate a process and make sure that you're asking all of the relevant questions, and then automatically populating a document that has all of the key phrases that you, as the subject matter expert, have vetted, I would say you are more likely to create a high-quality document than if you created every document from scratch, you tried to reword everything in a new way. I actually think the outcome is going to be better, faster, and cheaper if we go down this route. And that comes back to your first question, which is, I actually think this will benefit communities that ultimately have less access to legal services. If we can automate these processes, we will make legal services more available rather than less available, and we will improve quality rather than make it worse. And I would say, make a final point, and let's just assume for the sake of argument that the quality is not as good as going to a lawyer. That there are some things a lawyer might catch that you wouldn't catch with an automated questionnaire or something along those lines. The embedded assumption is that the vast majority of people are making a choice between going to a lawyer and using an automated service. I actually don't think that's the choice. 80% of the legal needs of the poor are currently going unmet because they cannot afford a lawyer. So the real choice is whether you're going to give people access to automated tools or they're going to have to do it on their own. I would much prefer people to use well-crafted automated tools than they try to do it pro se. So I think that is oftentimes the choice that people are having to make.
So as opposed to training lawyers with this process management expertise, what would be your argument for or against doing what most other services do, and they just hire people with that specialty from the business school to come manage their people?
Yeah, so good question. I've heard it's interesting. Is the concern that by developing project management and process improvement expertise or design thinking, you can get that expertise from a business school or from some other field, and so why train yourself up on that? We'll just get people from allied disciplines to do that for us. That's a possibility, except that's not the way the market is evolving right now. So law firms who are looking for project managers or design experts or these legal solutions architects, they're not going to people in other fields. They're coming to people who have legal training. And I do think that lawyers have something very special to add. We are bringing with us a knowledge about the law and the legal system, and having that innovation mindset on top of that allows us to build solutions that I think somebody from an allied field might not come up with on their own. Which is not to say that people from other professions and other disciplines can't help. They absolutely can, but I do think that the mindset that I'm trying to get at here will make lawyers better lawyers, even if they ultimately are supplemented by people who have other kinds of professional expertise.
Yeah, I was going to say.
From what I understand, Suffolk Law will be a host location for the Global Legal Hackathon,
Yes.
as is BYU Law. Do you have any practical tips for law students on how to get involved in creating legal technology, especially those on like the packaged and commoditized areas of legal technology?
So how to get involved? Well, it sounds like you already have some native expertise here in Law X. And I haven't looked at some other courses in the curriculum where you could learn these skills. There are also some training programs online that I think you could look to just to try to get a sense of how documents are automated. Look at some common platforms to get a sense of the logic behind them. Get a free demo of a tool to try out. And just, it's not like you need to learn how to code. People think that what I'm advocating is teaching lawyers how to code. I'm not. It's no more difficult than learning how to use Microsoft Word or Outlook or PowerPoint or anything else. Learn an automated legal document assembly tool, play around with it, see what it's capable of doing. Use it in a class that you have, some kind of transactional document class or litigation class, and there's a document that needs to be created. And really think through, what would I need to ask in order to create this document? It's a very challenging analytical exercise that it does require deep substantive expertise. But in terms of preparing for the global legal hackathon, that would be one way to do it, is to play around with existing platforms, many of which will give you a free trial, just to kind of get a sense of what it can do, and that might inform your thinking.
It's my understanding that Suffolk has had in the past at least a coding for lawyers class,
Mm-hmm.
and I'm curious what your thoughts are about what the role of learning code is, how
Yeah.
much is necessary.
Yeah, this is actually it's a controversial question among legal innovation and technology types, whether lawyers need to learn how to code. I would put myself in the camp that I don't think it's necessary. Could it be helpful? Yes, but I don't think it's necessary. I would much prefer to see lawyers just developing a new kind of issue spotting when it comes to the delivery of legal services. That is, that they are aware enough of the tools that exist that they know it when they see it, that they know that this is a service that could be automated in a particular way, even if they don't necessarily know how to build it themselves, which goes to the earlier question. There may be other computer scientists, computer programmers that you ultimately rely on and work with them to build a solution. I just want future lawyers to be sophisticated enough about what's out there that they know it exists and that they can explore that solution, not that they necessarily know how to build it themselves. So I would put myself on the camp that, yeah, programming is cool, it's nice. I don't think it's essential, in my view. And having said that, we do have a coding in the law class at Suffolk. And it's great if people want to take it, but I wouldn't put it at the top of the list of courses that I would want to see a law student take.
Which areas of law do you see as being most innovation-proof and will continue to require bespoke attention to clients?
Really good question. You'll get many different answers to that question. Some people will say nothing is immune from this process. I think some are more immune than others. And it's going to be the areas that are really immune from the kind of automation that I've described. It's going to be areas of law where there are gaps, conflicts, and ambiguities in the law, where you're going to need professional judgment in order to guide a client and strategize with the client about how to achieve a particular goal. Those areas of law, and you can find them in litigation work and you can find them in transactional work, right? In litigation work, it might be complex, bet the company, class action lawsuits, right? If you're defending those, you're not going to be able to automate the defense of that case. If you're talking about a merger and acquisition of two very large companies, some parts of that might be automated. I don't want to suggest that they can't be, but guiding the client and providing the kind of customized expertise and judgment about how to move forward is still going to require a lot of bespoke lawyering. So I don't want to suggest that bespoke lawyering is going to disappear. It's going to be out there, but I think less and less of it will be around. Yeah.
So can I just ask a follow-up question? Am I understanding that the more complex the client, they will tend to require more bespoke work?
So not necessarily. So the more sophisticated the client, there's still going to be more and more parts of what that client needs to have done that are going to be automated. I'll give you a great example. Microsoft is actually a good one. Microsoft is about as sophisticated a company as you could imagine. They used to use an outside law firm for their licensing agreements, right? One-off licensing agreements. They said, we're not doing that anymore. They went to a managed legal service provider who automated the creation of all of their licensing agreements and their non-disclosure agreements. So just because it's a sophisticated company who's the client doesn't mean that there aren't substantial features of what that client needs that won't be automated. So in other words, you can still have a lot of automation even in the most sophisticated clients in the world. And you could have very bespoke issues that arise for quite small clients. So I don't think it's small versus large. I think it's the nature of the work. I worked for a large law firm when I graduated from law school. You know what my bespoke lawyering was? Going page by page in discovery, because there was no electronic discovery. The discovery was all on paper. Going page by page looking for relevant information and responsive information. That's what bespoke lawyering was. That's not being done by large law firm associates anymore. So even though I was doing it for a sophisticated client, that part of the work has now become not yet commoditized, but more on that part of the spectrum. I know you all have to be going to class soon, so why don't we take a couple more questions? Go ahead.
Do you see the division in the market becoming more by the firm or by the client? So in other words, do you see firms becoming either sort of more of a bespoke firm or like Taylor or more providing the kind of the package flat fee? Or do you see firms providing the more bespoke work to the more sophisticated client, as you're saying, and the more flat fee to maybe the client that can't afford the bespoke customization?
Yeah, no, I'm seeing that the flat fee work is being demanded by even the wealthiest of clients. And maybe this wasn't your question, but so the companies now have so much data. They know what a employment discrimination matter should cost on average. And so they'll go out, excuse me, they'll go out to a law firm that maybe handles 100 of those matters a year for a large company. And they say, we know on average that it should cost X. We're only going to pay you that amount per case. And it's up to you to find the most efficient way of delivering that service.
So do you see there being more bespoke firms versus flat fee firms, or do you see all firms doing both kinds of work?
So I should differentiate between bespoke work and flat fee. You could do bespoke work and bill by the hour, and you can do bespoke work on a flat rate. So you could charge, I'm going to charge $10,000 to handle this employment discrimination matter for you. Okay, so it's flat fee. It may still require some bespoke lawyering on my part, especially if it goes to trial, right? That's very sophisticated work to try a case, which is another answer to the question about what's immune. Trying cases, although it depends what type of cases, because we could be seeing more online dispute resolution. So there could still be bespoke work done, even in terms of flat fee. I'm not sure I fully answered your question, but I do think that it can be quite. Did you want to follow up at all?
If you want to follow up, you should about. Let's thank Pete Perlman for his.
Yeah.
That's terrific.
Thank you very much.
Perfect.